abanyampi batujja balabisa tebalina kye batugamba oyogola baawo oyogola baawo oyo male mabirizi oyo munyampi n'abaganda bange abampeera abanyampi levo muli bakabi nnyo munyo buli ampeera omunyampi levo kibirizi na update webale muganda wange
Yes, a good morning to you, a good evening, a good afternoon, a good night, wherever you are watching this from. Just to let you know what is currently taking place. Remember, there is a case where Honorable Nyanzi is accusing, of course, the recently concluded MP-ship elections for Kampala Central not being fair, because almost more than 2,000 of his votes were not considered by Electoral Commission, and then it gave Nsereko to be declared as a winner. So Nyanzi went to court, and this is what is currently happening. The court ruling is going to be for today. I don't know whether the vote recount was done, so we are waiting to see what is going to take place at this court. And yes, let's pray everything goes on well, because these guys are mafias. Of course, Nsereko is a mafia. You know him very well. Recently, he came out and made allegations that we shall regret for voting out to NRM MPs. Really? Really? A statement from such a person who claims to be opposition, who claims to be pro-change. So those are some of the people Museveni plants within us to manipulate our people. So, of course, no doubt they rigged the election, and we are going to see what's going to take place today at the court. Yeah, the court session has not yet started, but it is going to start very soon. Very soon. Very, very soon. And then all I can say to you, first of all, thank you for coming out in big numbers to vote our President Kyagulanyi Ssentamu Robert. There is a narrative that is moving around that it is only Uganda that voted for Kyagulanyi. All I can say to you, wait a minute. Good morning to you, friends. I think you were not getting me at first. I don't know whether you were getting me. I just realized my microphone was, I don't know whether it was too low. I'm not so sure, but I think you are not getting me very well. All I was saying is that a good morning to you, a good evening, a good afternoon, wherever you are watching this from. Yes, it's a good morning, though the temperature is still too hot, the political temperature. It is still too hot, very, very hot. And of course, what is currently happening, Chairman Nyanzi, of course, was not contented with what came out of the results from the Kampala Central MP-ship. Of course, Nsereko tempered with the votes. You know, those are mafias, those are Museveni propagandists, that these guys as opposition, no doubt about that. And yes, actually, from Chairman Nyanzi's statements, more than 2,000 of his votes were not considered by Electoral Commission. So of course Nyanzi took it to the court, and right now I'm not so sure whether the court recount is done or what's going to happen next. All I can say, and I'm very sure of, the court ruling is for today, and we are going to soon get to know, and I'm sure the judge has arrived. Let me take you there.
bange omulamuzi azze teri kuddamu kwogera. Omulamuzi azze teri kuddamu kwogera. Omulamuzi ogwolaba teri kuddamu kwogera kati tusirise katubeere nga tuwuliriza omulamuzi ensala ye. Tubeere wamu kati tutandike.
Good morning, members of the public.
Nyanzi Fred Sentamu versus Nsereko Muhammad and the Electoral Commission.
Where is Nyanzi Fred Sentamu? Present. Where is Nsereko Muhammad? Present. Electoral Commission? No official. What do you think? Corporate reminded by half price. Kindly maintain silence. The rules remain the same.
Tusirike amateeka ga kooti bw'oyingira mu kooti sirika gyako essimu yo oba giteeke mu silence.
Those who want to mama and talk, you can go out.
Owulira nga tosobola kyekuuma okuba nga oyogera tuyambe ofulume.
I've given you 2 minutes to switch off your phones.
Obadde dakika 2 okuba nga muggyako amasimu gammwe.
And I hope everybody, I have my mask here, but because she's with a mask and I have to speak up loudly for you to hear, I'm not putting it on. But everybody should have their masks. Don't cover only the mouth, cover even the nose. And don't infect other people with your other diseases. Please.
Masiki zaabwe muziteeke paka ku nnyindo waggulu muzambale bulungi nga mulina okuzambala.
Since already we can't observe social distance, that one has been hairy. Proceed, Council.
May I please, Your Worship, my name is George Nsisi. George Nsisi. Here for the applicant.
For the applicant?
Yes.
Where is Bishop? Council Ahmed.
Council
His
Ahmed
name is Bishop.
is attending a trial, Jamil Mugul trial.
Then for the first respondent?
Your Honor, Bernard Mujawa and Saud Nsereko.
Yes, this matter is coming up for a ruling.
Just a moment. Where is Council for the second respondent? Electoral Commission? Here's another? What? Oh. Okay. So who is holding his brief?
None of us.
This matter is coming up for a ruling, and we are ready to receive it.
Are you ready to receive the ruling? Yes, sir. The ruling is in full here, but because of time, I'm going to summarize it. Where I need to go to details, yes, I'll do. Just be checking here. I found it. So miscellaneous cause number 15 of 2021 in the Chief Magistrate's Court of Kampala at Muwonge, sitting at Muwonge. Nyanzi Fred Sentamu, the applicant, versus Nsereko Muhammad as first respondent, and the Electoral Commission as the second respondent. My name is Nasambu Esther Rebecca Dono, Chief Magistrate. The above named applicant is Nyanzi Fred. So when I say applicant, without having read their names, is Nyanzi applicant. If I say first respondent, refers to Nsereko Muhammad, and if I say second respondent, it's Electoral Commission. The above named applicant, through his legal counsel, Press Advocates, filed this notice of motion under sections 55 and of the Parliamentary Elections Act 2005 as amended, and Order 52, Rules 1 and 2 of the Civil Procedure Rules, praying that this honorable court is moved to grant the following orders. 1, that the election results for the post of Member of Parliament of Kampala Central Constituency be declared null and void. That the election results and ballot papers for the post of Member of Parliament for Kampala Central Constituency be recounted and tallied before this honorable court. 3, and that the costs of this application be provided for. And his application was supported by grounds laid out in the affidavit sworn by Nyanzi Fred Sentamu, which this court has read and considered in the ruling. But briefly, excuse me, the grounds are that the applicant, who was a contestant in the 2021 Member of Parliament race for Kampala Central seat, was returned as the first runner-up by the second respondent, the Electoral Commission, having scored 15,975 votes, while the first respondent, who was declared winner, scored 16,998 votes. In third place was Ndilima Cedric Babu with 10,746 votes, while fourth place had Kaija Harold Sandron with 1,679 votes, and the fifth place had Mukasa Ronald Edward Senkubuge with 1,653 votes. This is attachment A on the affidavit in support of this application. That the voting process and counting of the votes were marred, and the whole electoral process were marred with irregularities and malpractices committed by the first and second respondents' agents, and that some of the presiding officers from the second respondent's office denied the applicant's agents access to the voting areas, and at different polling stations they were even chased away. For example, the site at Summit View polling area, Nakasero 1 and 2, Hoima Flats, etc. And that a lot of these DR forms that that a lot of these DR forms were never signed by the applicant's agents because they had been blocked from taking part in the counting and tallying process. That results which were recorded in over 50 DR forms, which tally with the official Electoral Commission return form for transmission of results, have clear arithmetical errors and completely different figures that cannot be explained by the Electoral Commission, and that all these polling stations with errors are named in paragraph 57, and for avoidance of doubt, in total there are 53. Court has not named all of them, and that because of these alterations and malpractices mentioned, the applicant was unjustly and wrongfully denied of his victory, that the applicant has taken time to count all the results on the DR forms, and it's clear that a total of 2,577 ballots could not be accounted for in different polling stations. And so it is just and equitable that the application for a recount is granted to enable the correct results in the ballots be announced. And Council quoted the case of Winnie Wanyima versus Ngomangime, 2001 case. The applicant was represented by Counsel Anthony Wameli and Counsel Katana Benjamin, while the first respondent, Nsereko Mohammed, was represented by Counsel Bernard Mutiaba, Stephen Galapzi, and Sauda Nsereko. And the Electoral Commission, the second respondent, was represented by Counsel Kolobi Hamid. The first respondent, Mohammed Nsereko, filed 7 affidavits in opposition of this application and was deposed by him and 6 of his agents. The agents are Labong Isaac, Narule Winnie, Nakakande Aisha, Kasango, Naguja Monica, Senoga Hakim, and Sekamate Hakim. Through his lead legal counsel, Bernard Mutiaba, the first respondent vehemently opposed this application on both factual and legal grounds that the application as presented is incurably defective, as it's majorly based on hearsay evidence. Hearsay, in simple terms, is lugambo, no proof, and that the malpractices complained of would not ordinarily fall under the court's ambits or limited jurisdiction as provided for under Section 55 of the Act. When I say the Act, is Parliamentary Elections Act, 2005 as amended. Secondly, the applicant is on a fishing expedition as insufficient evidence is provided to enable court effectively grant the reliefs sought for. Counsel further asked court to rely on the 7 affidavits of the respondent and his agents, of the first respondent and his agents, which this honorable court has done and considered in this ruling. And that briefly, the highlights are that the difference in votes between the applicant and first respondent is 1,023 votes, not 1,022 votes as counsel said yesterday. And counsel for the applicant alluded to the fact that the first respondent's agents' affidavits, which are annexed, have blank appointment letters. This counsel for the first respondent said is trivial because at the respective polling stations on which they have attached their appointment letters, the said agents or supervisors have attached DR forms which they duly signed, and their names are on those DR forms. So the counsel argued that the blank appointment letter is really trivial since there's a signature appended on the DR form. Furthermore, that the whole of Kampala Central constituency had a total of 126 polling stations out of which the applicant has selectively chosen to rely on 53 to allege the arithmetical errors. And of these 53, the applicant has reduced evidence in 28 polling stations, leaving out 25. And yet in all his arguments, he keeps repeating that he carried out an audit on all of them. Carried out an audit on all of them. And it seems like there is something fishy that the applicant, that being so, has to say there's something fishy that the applicant is hiding, and only he can best explain it. Why did he bring proof in the other constituencies, as in the other polling stations, as he had alleged? And that in the ones he has even brought to court, in most of them, he has been named as the winner, like in annexure FGIKLM, while in the others, the NRM candidate Ndilima Cedric Bobiwine. So now counsel for the applicant, or first respondent, wonders whether the applicant is denying his own victory at these polling stations, or did the second respondent or the Electoral Commission also alter the results on the DR forms to benefit him. Concerning chasing away from the polling stations the agents of the applicant and threatening them, hence making them unable to witness the tallying and final declaration of results, it should be noted that the court by court that no particular agent has been specifically named by the applicant. Say agent X was chased away from polling station Y, so therefore he signed DR form Z. And neither have any of the said agents deponed affidavits to show they were chased away from the polling stations to support these claims. This makes this claim total hearsay, hence inadmissible in court under section 55 of the Evidence Act. And in affidavits in opposition of the application, the agents of the first respondent have deponed to the effect that none of the contestants' agents were ever chased away, be it of the applicant, of the first respondent, or the other contestants. None of them was chased away by the Electoral Commission officials. And so counsel cannot comprehend or wonders why the very agents who are chased away again signed the DR forms. Because all the DR forms presented in court are signed by the agents of the applicant, who says these agents were chased away and they never signed. But the annexures he brought are signed by his agents. And none of them has even filled in the below the form where it is provided for in the law that where you protest the signing or you refuse to sign, you give the reasons. None of them filled in that part. Or even the returning office or presiding officer at that polling station filled in. And under the law of agency, the agent binds the principal. The agent here being the agent of the various candidates, the principal being the candidate. Because the candidate cannot be in every place at all times. The candidates, they are not God, they are not omnipresent. So they have to have agents to carry out their work. And once the agents sign any form on behalf of the principal is bound by what the agent has signed and is stopped from asserting otherwise. And that the paragraphs in support of the application from 38 to 94 is just repeatedly showing that the applicant carried out an audit, but has not attached a single DR form from paragraph 38 to 94. So this also leaves his assertions unhinged. They have nowhere they're basing to show out that he carried out an audit with no single DR form from those constituencies, namely paragraph 38, 94. So with no proof, it means these allegations are unhinged and should be rejected by courts. That all the affidavits in opposition have not been rebutted, making them unchallenged. uncontroverted and hence reliable, and the court should rely on them. The malpractices cited are not within the precepts of sections 55 of the Act, and that these matters can best be dealt with an election petition in section 60 of the Act as handled by the High Court. In conclusion, counsel for the first respondent says, though the applicant relied upon the authority of Winnie Byanyima versus Ngomangime, it is distinguishable from the current case because in that case there were only two contestants. That if the votes were not for Winnie Byanyima, then they were for Ngomangime. Here there are 5 contestants. So even the alleged 2,577 votes that the applicant says are left unaccounted for, court cannot ascertain to which particular candidate they belong to. Court doesn't know whether they are invalid votes. At the same time, doesn't know who would benefit, who would have the electoral benefit of having those votes, because they are not even in one polling station. They are scattered in different polling stations, which have not been named that maybe in this particular polling stations, 5,500 were not accounted for. And the application would have made better sense if the applicant stated particularly that he was given, say, 20 votes out of the 120 votes he officially received. He has not shown anywhere that any of his votes were removed from him and given to any other party or any other contestant. So this makes the application omnibus and a fishing expedition. Applicant wants court to make out a case for him instead of vice versa. You make out your case before court. Court doesn't make out your case before you. Court is an umpire or a neutral person in court where there are two sides. So I can't be seen to make out anybody's case. And that court should be pleased to dismiss this application for being moot. Moot is something like a fictitious, an example, something not really factual, frivolous, and a wastage of court's time, and has offended the provisions of direct evidence by providing us with hearsay evidence or rugambo without proof. And in addition, Counsel Sauda quoted the case of Nyakecho, Kezia Ochoa versus Electoral Commission and Grace Oburu, which was held in Bale High Court 2006. In that case, the applicant had to take court on a fishing expedition as well and locate the alleged votes that she thought were missing and should be given to her. So in this case too, the applicant, Mr. Nyanzi, or as commonly known as Chairman Nyanzi, wants this court to go on a fishing expedition to locate the 2,577 votes which he says the returning officer or presiding officers failed to count. And peradventure, the same may be added to his already existing votes, leading to his victory. Because the court can't tell to which person those 2,577 votes, if it's true, are missing, belong to any particular candidate. First respondent, through his agents' affidavits, has already stated adduced evidence to show that nobody was chased away, and that the agents all willingly and voluntarily signed the BRO forms. If there were any evident malpractices as alleged, they should have declined to sign, but they never declined. So in not declining, they bound their principle in whatever form they signed and accepted the results as they were. So the applicant cannot now turn around and missing ballots were his. Counsel prayed that the application be rejected and dismissed with post the respondents. Finally, Counsel Golobi for the Electoral Commission prayed that the court should consider the averments of in the affidavit in reply of Musime Doreen, returning officer of Kampala Central. This court has done so in this ruling. In her written reply, she states in paragraph 12 that she was notified of the petition on the 25th of January 2021 when she was served by court, long after the results and report had been transmitted to the Electoral Commission. And that in the cited case of Winnie Byanyima versus Ngomangime, the learned judge held it earlier that the returning officer should be informed at the time of the announcement of results before they are transmitted to the Electoral Commission of the need to do a recount, such that the transmission is delayed. For this case, the results have already been transmitted, and so this court lacks the jurisdiction now to develop into the electoral process of compliance and non-compliance of the elections. The electoral process is like a flowing river which waits for no man, and if not halted by a dam, it will continue to flow and leave you behind if you sleep on your rights. So is this application. It's not tenable in law and should be dismissed. And that in this, Counsel Golobi further states that in this application, the applicant applies to this court to declare the election of Kampala Central seat null and void. This, of course, is not in this court's mandate or jurisdiction to nullify any election. So the grounds that he has prayed for, as in ground 3, 4, 5, and 6, are not applicable to this court, and they cover malpractices and irregularities which fall into petitions filed in high courts. This application for recount is merely about the arithmetical errors and applicant showing a good cause that because of the errors done at a particular polling station, he was denied his victory. However, this application that the applicant filed calls for the scrutiny of the whole electoral process, which is the preserve of the High Court. And this court, as you may all know, is not the High Court, it's the Chief Magistrate's Court. The applicant in paragraph 7, 8, and 9 clearly states that he was informed, and informed. This offends Order 19 and Rule 3.1 of the CPR, which says, apart from interlocutory applications, a miscellaneous cause as this one, which is filed in court, should have direct evidence and not have this evidence of being informed without you having the truth of the matter. He prayed that court disregards the averments of the applicant and treat them as hearsay, hence inadmissible in evidence. The application for recount should be only granted on sound legal grounds and sufficient cause. Arithmetical errors per se are inconsequential, since they do not confer an electoral advantage to any candidate in particular, hence warranting court to grant this order. Yet still, all the DR forms were signed by all the agents of the parties involved, applicant inclusive, and the applicant's agents who signed in law bind him to the results on the DR form as is the principal. Therefore, he is stopped and cannot deny the results that he was given and is stopped from opposing the said results. This was held in the case of Gagawala Wambuzi versus Luvogo in the Jinja High Court, 2011. So, Gagawala's agents signed the DR forms, he ran to court, and he was told that he was stopped since his agents signed the forms and accepted the results as they were. Then, Council of Electoral Commission finally said there is a glaringly huge margin between the applicant and first runner-up, the applicant and first respondent, that for a recount to occur, jurisprudence has shown that courts always consider the margin before counting. In this case, the margin between the applicant and the first respondent is 1,023 votes. That margin is big, and court should judiciously or take caution if it is to grant a recount in such an election where the margin is glaringly huge. In rejoinder, Councillor Ahmed reiterated that his earlier prayers and submissions and continued to pray that this Honourable Court grants this application and orders for a recount of all the votes in Kampala Central constituency. This court has heard and listened to all learned counsel, attentively read all the pleadings, carefully rules that this application is brought under Section 55 of the Act, which is clearly part of the segment of the process of counting of votes and announcing of results, and the jurisdiction of this is vested in the Chief Magistrate's Court, and a recount under this section is merely a legal function performed under the neutrality of the courts and intended to untangle numerical equations of the results as part of a voting process. The issues raised by this court to resolve the questions before it are whether the grounds raised by the applicant for recount are in the ambit of Section 55 of the Act. 2, the remedies available. As earlier stated, court has laid out the purpose of Section 55, and for a court to do a recount or exercise its jurisdiction to do a recount should be done so judiciously, and that 1 or A, the applicant should have made his application within 7 days following the day on which the returning officer declares the results of the election, and 2 or B, the candidate intending to apply for a recount should immediately inform the returning officer under Section 55(1) of the Act of his or her intention to apply for a recount. This notice serves to arrest or delay the rapid flow of the electoral process to enable the recount fit within the proper location. C, upon the notice of intention to apply for a recount, the returning officer shall delay the transmission of the results to the Electoral Commission. D, good cause must be shown by the applicant to the satisfaction of court on a balance of probabilities, since this is a civil matter, it's not criminal, which has to be proved beyond reasonable doubt, and that a recount ought to be done. The court must, before commencing a recount, be satisfied that the purpose of the recount is achievable. For example, that all the ballot boxes presented by the returning officer for the purpose of a recount must have been and should still be sealed as required by Section 51, subsection 2 and Section 53 of the Act. Court has analyzed these conditions as set out in the case of Winnie versus Ngomangime. For A, the applicant met the deadline. The results were announced on the 15th, so the day following the results announcement is 16th. He filed his application on the 22nd of January, so it is within the 7 days as provided for by the law. And then in B and C, the applicant who intended to apply for a recount did not notify the second respondent's official, who is the returning officer, in time that he intended to apply for a recount. This recount seems to have come as an afterthought. Hence, on making the application, the returning officer in half-David told court that the results had already been transmitted to the Electoral Commission. D, good cause must be shown to warrant the recount, or sufficient grounds must be proved. The applicant in this case brings evidence of numerical errors after his audit of all the DR forms. He also alleges malpractices and irregularities, connivance between Mr. Nsereko and the Electoral Commission to chase away his agents, and concludes that there are hanging 2,577 votes which ought to be counted, and that maybe after that, he may emerge the victor of this election, the Kampala Central. As noted by both counsel of the first and second respondent, most of the allegations of the applicants are not based on factual evidence. They are based on hearsay. He has not even provided a single affidavit from his agent who was chased away from the polling station and did sign the DR forms. And neither has he produced any DR form which is not signed by any of his agents. And he specifically does not name the agents, like agent A, B, or C was chased away from polling station D, E, and F. And also does not show the court specifically where to find those missing 2,577 votes, implying and confirming that what both respondents' counsel submitted, that the applicant wants to take court on a fishing expedition. This court politely declines to oblige to that fishing expedition. The threats, malpractices, undue influence, duress, intimidation are not a preserve of this court, neither do they fall under Section 55 of the Act. These are grounds handled in a petition filed in the High Court as in Section 60 of the Act, and do not form a basis of a recount. I say, all the applicant's agents on the DR forms they attached to his application duly signed the DR forms. So court wonders which agent was chased away and did sign the DR forms. And the applicant is bound by what he brought to court. And he's also bound by his agent signing. The agent signed the DR forms accepting the results, so they bound him as the principal. So instead of blaming the Electoral Commission or the first respondent, the applicant should now turn his guns to his agents and scrutinize his agents and find out if they did their work to the satisfaction or to the best of his interests, or probably these agents had become double agents and it acting for his good cause or interest. The applicant has not shown sufficient cause and premised this application on mainly hearsay, which, as every lawyer here knows, is inadmissible in evidence in court, except for certain qualified situations where this does not fall in. And also, this petition is not an exception to the hearsay rule, so they have to produce the evidence to prove the facts. And also, the applicant asked this court to nullify elections. That was his first prayer, and declare the seat null and void. This is not the preserve of this court. It is done by High Court to nullify elections. So no good cause has been shown to warrant a recount. About the storage of the ballot boxes, this court cannot certainly ascertain whether the ballot boxes are still intact or they have been stuffed with either ballots or some have been removed. Neither can it tell whether the seals are still intact or broken. So, to carry out a recount, court should make sure that the purpose for the recount is achievable. And since court is not the custodian of these ballot boxes, it puts court at the mercy of whoever stored them, and court does not want to go there. Having proved that the applicant did not have a good cause to warrant a recount, these are the remedies. So, no good cause has been shown, and there is insufficient and irrelevant evidence adduced, mostly hearsay, and that at this stage, the application for vote recount of Kampala Central Constituency is hereby dismissed with posts going to all the respondents.
Abakyekumidde ku channel yaffe eno nebivudde mu kulonda era omulamuzi abadde nga agoba omusango gwaffe era tugenda batugenda olwa honorable chairman Nyanzi abeere nga atunyonnyola kitazaako tugenda batumufuna abeere nga atunyonnyola kituliko ssaawa zino tugenda batumufuna wabweru atubeere nga tufuna ebigambo bya chairman twagala kubeera nga tufuna ebigambo bya chairman babeere nga batubuulira ekiddako oba tugenda batubafunamu obweru simanyi ne kansu babeere nga batunyonnyola.
Well, court has noted that whereas there were arithmetical errors, it has agreed with the law of the Electoral Commission that arithmetical errors may not have been consequential, whereas there were ballots which could not be accounted for, over 2,000 of them. Court has said that whereas those ballots were not accounted for, it could not place where they are, and later on court also said that it could not confirm that the ballot boxes are still intact. Because of the several allegations of malpractices, which were even considered by the Electoral Commission, which organized the election, the remedy lies in having the election challenged in the High Court, where all these other allegations of malpractices shall be adduced, and we shall seek court's indulgence on that.
So you're going to the High Court now?
Certainly, we are going to challenge the election in the High Court.
Okay. Uganda, Church Dako.
Kooti olwaleero esaza omusango negamba nti wadde twagigamba nti obululu 2,205 tebusobola kumanyibwa mayitire gaabo, naye tetusobola kumanya ani yandibadde abufuna. Ekirala nga looya w'Electoral Commission yagamba kooti nti emivuyo mu kubala obululu tegyali gy'amaanyi nnyo, ate nga ffe mugunya ku kyali kya numbers. N'olwekyo olw'okuba nti kooti ekkiriziganyiza nti emivuyo gyali mingi nnyo nga gisukka ki kooti gyesobola okukola, era ne looya w'akakiiko kye yagamba, olutalo tugenda luzza mu kooti enkulu gye tugenda okulwa obujulizi obwo bwonna kubanga kooti n'ekirala egambye tiyinza kukakasa nti boxes zikyali wezimu nga bwe zaaterekebwa ate negamba nti yagala kuwa order gyetakakasa nti boxes zikyali sealed oba zikyasibiddwa nga bwe zaali ziterekeddwa. N'olwekyo olutalo tugenda lwongerayo mu kooti enkulu gye tulowooza nti tujja kugikakasa n'obujulizi bonna era tusabe okuwangula okwo era kusazibwemu.
Yes, Chairman Nyanzi. Yes, like my counsel has said, you can win the battle, but the war is not over. It's just a beginning. I will just request my supporters to be firm and more courageous. We are heading on with another battle in the court by fronting another petition. Abawagizi bange mbasaba babeere bagumu. Bino byonna twalisuubira. Nze okusinziira nga bwe ndabye omulamuzi siri mumativu ng'egyasaze musango kubanga asinzidde obukwakulizo obwandibadde mu petition ng'oba agent n'atayimirira ku nsonga enkulu ez'obululu, ennamba z'obululu, ng'ate omusango guno twaguluupa nga tusinziira ku nnamba z'obululu ne DRA foomu zonna nga ziraga nti obululu tebwataalinga. So ndaba ng'omulamuzi naye ekintu takisalidde mu mateeka matuufu kubanga ensonga enkulu tubadde tusaba recount zoliki ekiri mu box kati kubanga ne bandibadde bamukyusiza obubox nga bwagambye tebasobola kukyusa byonna, tebasobola okukebera buli serial number mu fidgeting yandibaddewo era ensonga lwaki olaba badde bafuba nnyo okulaba nga bakirwanyisiza wano mu kooti. However, ffe tutakkiririza mu kooti, we still believe in the rule of law. We are going to resort to the High Court by fronting a petition. Thank you very much.
Oyo chairman waffe, chairman Nyanzi. Ebintu bibadde kooti bwete bwewadde ensala ye era nga ebadde nga egoba omusango guno, naye nga chairman Nyanzi atutegeezezza nti agenda kubeera nga annyonnyola oba agenda beera nga apiiringa mu High Court kuba kooti eno ebadde nga egoba omusango guno. Kooti eno ebadde nga egoba omusango guno agenda banga apiiringa mu High Court. Mwebale nnyo abakyekuumidde ku channel yaffe eno. Kyonna kyokola kyamaanyi nnyo, kyonna kyemukola kyamaanyi nnyo. Kyonna kyemukola kyamaanyi nnyo. Olina ku charge power bank bangambye mu power bank kasiyo sina wepita wali naye nga ekyo power bank eno gye nnina yekyanze weddeko omuliro. Njagala kubeera nga nfuna power bank tubeere nga twogeramu ne baganda baffe abalala ne ba lawyers abalala baloya b'NUP babeere nga batubuulira bo bakirabye batya bo nga bo bakirabye batya bagenda batunnyonnyola bo bwe bakirabye era nga ngenda banga nkutegeeza yes tuli live mu kooti era tuli Mengo ssaawa zino. Omulamuzi abadde nga agoba omusango gugobeddwa gwo. Omusango gwo gugobeddwa naye Honorable Chairman Nyanzi ye agambye nti agenda aba apiiringa mu High Court kuba ensonga ze boogeddeko wano yesize yawateeka mu fayiro ye yateeka mu lipooti ye era nga agenda akola appeal mu High Court kugenda batubifuna byonna tugenda batubifuna nga tulina okuba nga tubifuna. Njagala tubeere nga tufuna ebigambo ebisingawo ku ebyo era nga walaba Chairman Nyanzi aliba nga annyonnyola eggwanga ki ekiriwo. yasooka kubanga afuna
simulaba ena power bank
kono abantu
wangudde ne akatiko by'okulonako tekalina bwe kaalaga nti n'obululu obwo 25 okusobola okumanyibwako amayitire. N'olwekyo ekiddako tugenda mu kkooti enkulu okusaba okulonda okutwalibwe era tusaba okuddamu okukeeka akalulu ka Kampala era tulowooza nti olugenda ajasobola okukakasa kkooti. Ekiragiro kya kkooti kaakati tujja kiteekako ekiragiro kya kkooti kikolebwako mu ngeri
abalonzi bange abasinga bamanyi babadde basomye kubanga judiciary naye yokka gimu mu kiseera kino era n'okusaba abalamuzi b'engerege ensonga ze bayimiriddeko okusala omusango gwonna zibadde za petition okubuuza baali nti obujulizi baakubwa enyadde ya petition etugenda mu high court. Omusango ono twaguleeta nga waliwo enjawulo ebyala foomu ezasobolwa abagenti bonna ne bakuza gyewoofiisi enamba y'obululu totaalinga na muwendo bwalangirirwa. Obululu bwe bwalangirirwa bungi nnyo abalonzi abalonda kati ng'ekyo kizulira mu bokisi kati situli bamativu omulamuzi okugaana recount naye nga bw'omanyi nti tuli mu lutalo olw'okumanyisa tugenda kugenda mu maaso kubanga luno lubadde lutabaalo olutalo lukyagenda mu maaso nga kanso bakugambye twala kotisinya koti yawa
kanso
ekitako nti nga bwe twabye mu kkooti egambye nti ebibiyo byonna ebyetoleka mu kulonda kwa Kampala Central ekiva mu maaso gaayo erina buyinza okugibuulirizaako. Ekyokubiri negamba nti olw'okuba obululu 2025 twalaga nti tumanyikiddwako mayitire nekkiriziganya n'erula w'akakiiko by'okulonda nti wadde obululu 2025 tumanyikiddwako mayitire naye tetwamanya bwali bwani. N'olwekyo nga looya w'akakiiko by'okulonda bwe yagamba nti obululu nti mu kuteeka okulonda ebivuyo gy'okubala si kyamaanyi nnyo so nga ate enkaayana yaffe ebadde ku nnamba y'obululu. N'olwekyo ekiddako tetupanyiza na nsala ya kkooti wadde tukiteekamu ekitiibwa naye olw'okuba olw'emivuyo gyetoleka mu kulonda kuno ne kkooti gyerabye n'etusindika ewalala nti tulina buyinza gyebulirizaako tugenda kugenda mu kkooti enkulu kuba kyetwali tubala kyetwali tusaba twali kyakuddamu kusaba kkooti egambye tekakasa nti oba bokisi ezo zikyali nga bwe zaali negamba teyagala kuwa kiragiro nga bokisi zakyukakyuka dda. N'olwekyo tugenda kugenda mu kkooti enkulu nga kyetusaba kyakusazaamu kalulu aba n'abantu abalangirwa era tusuubira nti mu kkooti enkulu tujja kusaba ekiragiro ekyokuddamu okulonda mu waka kwa Kampala Central bwe tunaaba tuggyeeyo emivuyo egyo gyonna gyonna nga bwe tugyewolesezza mu kkooti negamba nti emivuyo wadde tugirabye naye tetusobola okugibuulirizaako. N'ekyo tujja kugenda mu kkooti esobola okugibuulirizaako era nga tukakasa nti bwe tunaaba tumaze ennyo ekyobukkiriza omwo tujja kusigala nga tulina kyakukola okujjako okusazaamu okulonda kwa Kampala Central tudde mu tulonde omuntu abantu gwe balowooza nti y'anaaba asinze. Court has made the decision. We respect it, although we disagree with it. Court has noted that whereas there were several arithmetic errors that whereas there are over 2,000 votes which are not accounted for, those votes could not be attributable to any of the candidates. And of course, like even the Electoral Commission lawyer conceded that the arithmetic errors which occurred were not consequential. You can imagine the EC saying that the arithmetic errors were not consequential in an election. Our dispute was over ballots. Court has also noted that it does not know the sanctity of the ballots of the ballot boxes for now, since they have not been in its custody. It's not sure whether the ballot boxes have not been tampered with, and therefore it noted that it didn't want to issue an order in vain. In light of the malpractices that have been shown in court and which have not been controverted by the respondents, we are going to table the same evidence before the High Court, the court which has a duty to inquire into all those malpractices. And we believe that if we finish that, the court will have no option but to cancel the results and the election of Kampala Central, and we shall seek a by-election.
MP omulondo wa Kampala Central. Ye MP omulondo wa Kampala Central. Wadde nti waliwo okwagala okukwata mu kalulu. Bakwata mu kalulu obululu 2,205 tebumanyikiddwa we buli. Abo boolaba abawaga abo. I'm sorry.
Okay friends, thanks for watching. Let me hope you get me very well. And that has been the court ruling. It's dismissed the case. However much it has noted there were irregularities during the voting process before and even after. But it is saying as if it doesn't have the mandate, doesn't have the powers to go on with the case and the irregularities mentioned by the applicant. So you wonder a type of a court which identifies the arithmetic errors and all that kind of thing, and then it goes ahead to dismiss the case. All I need to tell you, Chairman Nyanzi, over 2,500 of the votes vanished in the air. Those are the ones that need to be accounted for. The court, of course, identifies that, but it is like they don't know whom those votes would go for. In brief, they are saying they don't know whether they would be for Nyanzi or they don't know whether they would be for Nsereko. Anyway, in brief, the situation, all this kind of madness, election fraud, bribe out of the court, and all the impunity, injustice, and all the kind of irregularities in most of these institutions you see, is not going to come to an end. It can only come to an end if we vote Museveni. Sorry, not even we vote Museveni, because if we take out Museveni by all means, if we take out Museveni by all means, then we can redirect our institutions back to their true meaning, as in they have to be independent. They don't need to be affected by orders from above and all that kind of thing. So basically that is it. This kind of injustice you see, where the court can identify irregularities and then it goes ahead to dismiss a case, they're not going to come to an end, because we are not living in a democracy. We are not living in a democracy. All we need to do is to stop lamenting, to stop commenting on social media posts, to stop doing all that kind of thing, come out in big numbers and say enough is enough to this madness that is going on in this beautiful our country, the part of Africa. If we do not do that, killings, the torture, the illegal arrests, and all that kind of thing is going to continue to show up. So what would be the solution for this? Because the court is saying that maybe the ballot boxes are tampered with. Yes, you saw a case in Masaka in Kalungu. The only solution for this, of course, the other time Sempija had tampered with the ballot boxes. The only solution for this Kampala Central MPship position is to organize another election for this position. That would be the only solution. That would be the only solution, because the court now is benchmarking on petty claims. Even the applicant didn't capitalize on. The only solution would be for a rerun of this election. That would be the only solution. That would be the only solution. Now, guys, thanks for voting Kyagulanyi Ssentamu Robert. Man, people voted for Bobiwine all over the country. Of course, in the Western, you know how it is always done. They vote for them, especially for the position of president. You come and they're like, we have already voted for you. You are going to vote for the MPs and all the other candidates, but for the president, we have already voted for you. Of course, not everywhere, but in most of the places, especially when you go deep down in the villages. So that's what happens. And of course, you saw what happened. All agents were chased away. This mostly happened in Western Uganda. And thank you for voting for Bobiwine, because it is now, it has to take electoral commission more 2 to 3 weeks to compile the results. They announced within 48 hours, and then you wonder which type of people these are. So of course, don't lose hope. We anticipated this. That's why some of us are not shaken. We are still very, very, very strong, and we know that it's not yet over until it is over. This is a mission to freedom. It is not an overnight kind of a task. It's a process. You know, it's a process. You're not going to wake up one day, within one day, and boom, Museveni is gone. No, it is going to be a process. And at the end of it all, we are going to see our country redirected back to the right path. All you need to do is to be part of that process. You need to be part of that process, whereby if your kids, if your grandkids ask you what you did, you have a story to tell. Because all I can say to you, there's going to be a time when all these kind of happenings are flashing before your eyes. You know, you'll be like watching a movie, and then you should be able to watch it over and over again to see yourself being part of the process that redirected our country back to the right path. What am I saying? Find whatever you can do, capitalize on it. The mission is still on. The mission is still on. Whatever you can do, do it. Yep. It is just the beginning. It's not yet over until it's over. Remember, this was not election in 2021, but it's a mission 2021, and it's a process. Election process was part of the process. Our mission is not yet accomplished. Who is going to accomplish it? Us. Kyagulanyi has done his part. He has played his part. He flipped the script of his celebrity life, his comfortable life, took it upon himself, opened our eyes, sacrificed his job, sacrificed his life, sacrificed his family, sacrificed his friends, sacrificed everything. Now it's upon us to finish this mission. It's upon us to finish this mission. What I can say to you, there is no condition that is permanent. This is going to come to an end only if we capitalize on what we are doing. Alright guys, thanks for watching. Let me make it, let me just stop it there for today. Continue spreading the message of change, the message of mission to freedom, the message of